Chris Hipkins.
Chairman, and I appreciate this opportunity to make a contribution to this, and I want to turn my attention to Part 1, Clause 5, which amends Section 144 of the Act, and I want to talk to Clause 5 of that particular clause because it deals with the hearings panel and the recommendations that it can make. And the issue that I want to canvass, which hasn't been canvassed by any of the other speakers so far, is the power that the hearings panel is being given to make recommendations outside of the scope of the submissions that it has received. So the conventional wisdom, if you read the rest of the section, would be the purpose of a hearings panel is to put forward a plan, get the feedback on the plan, and then make amendments for how the plan may be changed based on those submissions. But this particular clause gives the hearings panel a much wider remit than that. It says that the hearings panel can basically do what it likes, regardless of what the submissions are actually saying. So they could actually go through and they could say, well, there's some issues that we feel are important that weren't raised by any submitters at all, and we're going to make recommendations based on that just because we feel like it. It gives the hearings panel quite a significant scope. And I think that stands in a bit of a conflict with, if you look at Clause 8C of what the report, which specifies what the reports of the hearings panel must include. The report of the hearings panel must include the reasons for accepting or rejecting submissions, and for this purpose may address the submissions by grouping them according to, etc., etc. So basically it says that the hearings panel basically has to go through the submissions and say whether they're going to be accepted or rejected, but then it can throw a whole lot of other things on the table that it doesn't have to go through a similar kind of process for, because they can just make recommendations of their own right without reference to submissions. And it seems to me that if the purpose of the hearings panel is to get public feedback on the plan, why would we give them this much wider power to make whatever recommendations they feel like? Because bear in mind that the recommendations that they make that aren't related to the submissions could well be things that the submitters would have had a view on and would have wanted to make submissions on had they known that those were the items being discussed. So potentially what this does is it means that the recommendations that come out of the report of the panel can be can recommend quite significant changes to the plans without bearing on the submissions. And it seems to me that that cuts against the whole purpose of what this is all about. The other point that I want to deal with is 1441, which says that the hearings panel must make recommendations on the proposed plan. And the question that I've got is, why is it necessarily a must? What if, having heard all of the submissions, the hearings panel decide that they don't want to make any recommendations? They're actually quite happy with the plan as it stands. Why the word must? Because I think, again, that cuts against the grain. And when you consider that in light of Clause 5, which says that their recommendation-making powers are not limited to the matters on which people have been submitting, basically it says, well, if they go through all of the hearings and they don't want to pick up any matters that were covered in the submissions, they must make some up. They must actually come up with something, because they're not given the option of not making recommendations. They are told that they have to make recommendations. And so I think that is something that's, I'd like to hear a justification from the Minister on both of those points. First of all, as to why they are given this wider power to make recommendations that fall outside of the hearings process. So, this is a hearings panel, and so why does the hearings panel have the ability to make recommendations on issues that it has not had hearings on and it has not received submissions on? The second point is, why is it that they must make recommendations? And of course, they're coming back to some other contributions to the debate. I think that raises issues around the constitution of the panel. What happens if the panel is unable to reach an agreement because they've been told that they must make recommendations, but they might not necessarily be able to reach an agreement on what those recommendations should actually be. So there are a whole lot of questions here that haven't been answered by the government, because aside from a very brief aside from the Minister, which clarified one issue and actually probably raise more questions than answers. We haven't heard from ministers around these quite detailed and specific questions members have been raising.
Tim McIntyre.